SJC-11562, John Doe number 68549, the Sex Offender Registry Board.
6-2. Thank you.
Good morning, Mr. Demento. When you're ready, you may
Yes,
proceed.
Yes, thank you. This is an appeal from a decision of the Sex Offender Registry Board classifying the appellant as a level 1 risk. The offenses for which the appellant was convicted were 7 in number. That is, there were 7 episodes, 6 involving a male cousin, younger than he by 2 years, and 1 involving a female cousin who was a couple of months older than he was. The 7 episodes were, by the way, there were 12 counts of conviction, but some of the episodes were double charged, so that there were actually 6 episodes involving the male cousin and 1 involving the female cousin. They occurred over a period of 3 years. The first offense occurred in early 1986, slightly before the appellant's 14th birthday. And the last offense occurred in December of 1988, about 4 months before the appellant's 17th birthday. All the offenses, the offenses against the male cousin, the younger male cousin, occurred during sleepovers at the appellant's home. They were, the families were pretty close. And the offense against the female cousin occurred at the swimming pool of the appellant's home.
And when were the criminal proceedings were 12 years later?
Yes, yes.
Okay,
They didn't
and so
come-
the registration is all occurring when he is well into adulthood?
Pardon me, say?
The requirement to register is occurring when your client is well into adulthood, correct?
Oh, yes, oh, yes. And the registration law occurred long after the offenses, so we have the ex post facto that this court has already passed through. The board's decision in April of 2010 comes 22 years after the last offense, and we are now about 4 months short of 26 years from the last offense. The examiner, faced with these facts, ran down the list of what I call guidelines, what are known as regulations, ran down the list of regulations, and relied chiefly on 4 of them as I see it. First of all, there were multiple victims. 2 makes it multiple. That is the 6 episodes with the male and 1 with the female, so we have multiple victims. We have a long duration of the offending conduct, almost 3 years, which is considered to be important and useful information in the guidelines. The multiple victims is in the guidelines characterized as giving up a heightened risk of reoffense and a greater degree of dangerousness. And then the third guideline on which the examiner relied heavily was that the conduct was repetitive and compulsive. And I believe, although I can't be sure, I do not I don't interpret the guidelines or the regulations as using compulsive in the medical sense of something you have to do, even even though you're compelled to do it, even though it's against your will. They call it compulsive only because you have time to reflect between the repetitive conduct, between each of them, so that if you have time to reflect and you think about the wrongfulness of it, it must be compulsive. So everything that's repetitive, as a practical matter, is compulsive. And
So
then,
if he were 16 years old, if he had been immediately prosecuted and was before the SORB when he was 16, would you have any dispute with the level 1 classification?
none.
Okay, so
But-
it's,
Excuse me.
it's the passage of time which you say is what distinguishes this case from a comparable case involving a juvenile.
Well, if we were here back in 1988 or whatever, and we had some way that you could be sure that you could look ahead 22 years or even 26 years as we are now, I would be arguing as I am now. But we have the benefit today of these guidelines are designed to tell us what the risks are in the future. They're designed to read the future, to predict the future for us. But now we know the future. The future is past. And I just don't see the use of the guidelines any longer.
But I take it that you or whoever handled the hearing below didn't submit a series of studies, updated studies, or anything of that on which the hearing examiner could base going beyond the guidelines or factors, correct?
Yes, I have represented this appellant from day one.
Okay.
And
And I know you had evaluation reports done, I understand that, which were submitted to the hearing office.
yes. But I don't know if I'm reading too much into what Your Honor has just said, but I do want to acknowledge that we have the amicus brief on juvenile, and I think I should as well point out to the court an opinion of this court, speaking through Justice Link in these Doe numbers, 205-614, but it is 466 Mass 594 at page 603, footnote 7. That opinion was published last December, and in that opinion, Justice Link writes at that footnote that an article published 2 years after the close of the record is acceptable. That is, the court will update the science here.
Let me ask you about the science. Now, what is it that you say is missing from the current scientific understanding as reflected in the SORB guidelines that would have application to your client? I mean, you just acknowledged that if your client were convicted as somebody who'd done these things at 16 and was convicted, sentenced, and had to register, that being a level 1 offender would be an appropriate classification for such a person. You're saying it's the passage of time. Are you saying there's something? I'm having trouble understanding what you're saying is missing from the guidelines.
Oh, well, first of all, I've said it's the passage of time that's important, but it's the combination of as well. You have a juvenile as well as the passage of time.
Are you so
And
like
so that-
revisiting then your comment that you would have been satisfied with a level 1 classification had your client been immediately subject to the registration requirement and gone through the SORB process and came out a level 1? You're saying that's appropriate. So I don't understand if that's appropriate. And the client is still a juvenile and all the rest that goes with that. What's missing? What's different in the guidelines?
The guidelines, if I understand your question correctly, The guidelines are deficient in this respect. Not one of them addresses the particular problems of a juvenile with reference to modern science, the hole in the head science, so to speak. Not one of them does that, nor does any one of them deal with the passage of time. And in combination with those two deficiencies, it has to be that the examiner has to move out of the guidelines and look at what the experts say.
But did you give the examiner any expert evidence as to what the experts do say about the combination of being a juvenile and the passage of time?
Oh, yes. Oh, yes. We had 3 experts. 2 of them were testified, and one of them submitted a report. And those 2 experts, one of them was Dr. Katz, a psychiatrist mistakenly referred to as a psychologist in the opinion of the examiner. And Dr. Katz testified that plaintiffs, well, he was plaintiff there, his behavior, as odious as it was, and of course, all of these things are ugly. None of them are pretty, unless you want to say they're pretty ugly. As odious as it was, represented an adolescent adjustment reaction and was not indicative of emerging sexual predatory character pathology. It was a transient episode in the life of a mixed-up teenager at the time, which is what it was, and it was transient and it was gone. He grew out of it and has gone on to live a normal adult life without any significant discernible psychopathology. It's my recommendation, from a medical point of view, that the name does not present any danger in the community, sexual or otherwise.
But the examiner didn't have to accept that opinion about this offender, right?
That's right. And then, in this case, but although you do have cases where the party with the burden of proof has all the evidence, the other party has none, you've got to weigh that in on the substantial evidence test. So while they don't have to, it seems to me you can't ignore it if you've got nothing backing yourself up, backing up the SORB, except the regulations which are not tailored to this specific case. These regulations are so general that I don't believe that anybody who wrote them believed that they would fit perfectly any case. Then on cross-examination, Dr. Katz explained that the plaintiff was conscious of being fat, had poor self-esteem, wanted to be one of the cool guys in high school. He was tongue-tied, afraid of girls, teased by the other boys for still being a virgin. And he thought of himself as a hanger-on, that nobody came around to see him except that his family had a pool.
Did the experts who testified or who submitted a report make reference to scientific studies?
Yes, Dr. Schwartz did. As a matter of fact, Dr. Schwartz brought it to the attention of the examiner that it's now come into the public domain, and there is in the record an exhibit of an advertisement by Allstate Insurance. Why do juveniles act like they have a hole in their head? And the answer is, well, they do. But going back to the question of to what extent the examiner can disregard the testimony of an expert, let's look at the grounds on which he did it here. He said here that he had to reject the testimony of Dr. Katz because his testimony was not in the context of the regulations. In other words, he expected Dr. Katz, just as he is required to do, he expected Dr. Katz to fit this into the regulations somewhere and to speak in terms of the regulations, where, of course, the regulations just don't fit these facts. Dr. Schwartz testified as to the science and taking up something that appeared in the last argument. Dr. Schwartz herself said that she would not score herself as a zero risk of sexual offense, and she said that sitting in a wheelchair. So I just want to pass that point. I hope we're not talking about zero risk, but we are talking about a juvenile with a hole in his head, and we do know we have the full advantage of hindsight, 26 years as of now, unless, I see time is up pretty quickly.
Thank you.
Thank you, counsel.
Good morning. Jennifer Zelnowski, representing the Sex Offender Registry Board. The plaintiff is really attempting to make this case into something that it isn't. Yes, he was a juvenile when he committed his sex offense. However, some of the points being raised here today, he didn't submit any of the studies or articles that he's now relying on with regards to the status of a sex offender or adolescent brain development. Second, with regards to the expert opinions, the board would assert that the experts in this case barely touched on the subject that's now being raised before this court. And although they did discuss the fact that he was a juvenile, this isn't something that was lost on the hearing examiner in his decision. But the experts themselves don't raise these issues that are being raised now. Third, on a somewhat minor level compared to the other two, the board would assert that the U.S. Supreme Court cases and the recent case out of this court regarding juvenile criminal cases shouldn't influence this court's decision on this case.
Well, let me ask you this, though. You do have this circumstance where these offenses are committed a long, long time before this hearing that is supposed to be assessing risk of reoffense is taking place. And there has been no, I take it, no reoffense between 1988 and whatever the years are, 1988, 1989, and when this hearing is taking place. Isn't that a fairly significant fact?
I think there is a significant period of time there, and the hearing examiner takes that into consideration, but that's not unusual with our cases. And there's nothing to suggest that.
But
I'm
then
sorry.
what, if it's not unusual in your cases historically, but presumably it's, well, why isn't that a very large piece of information with which to deal? If you're trying to predict, if you're trying to reach some level of rational prediction as to what is the risk of reoffense, and you've got a history of, how many years is it, 12 years?
There's 12 years in between from the time that the victims report until the offender is convicted as an adult.
Okay. And then this hearing is when?
And then this hearing takes place, well, there's two hearings, because initially he was classified as a level 2. It's
Okay.
remanded back down, he gets another hearing, and he comes out as a level 1.
Okay.
Which is appropriate. And as I was saying, the hearing examiner in this case does take that into consideration, that there's been this passage of time, but when he weighs it against some of the other information that's before him, that's not going to outweigh the fact that there is still a low risk. And that's what we're talking about. And it, it was obviously discussed in the earlier cases. There is a difference between no and low. And in this case, the hearing examiner found that it was low, and the Superior Court agreed with him that there was a cognizable low risk in this case. And I think the other thing that is interesting in this particular case, because it is a bit of a different fact pattern, is that this case, because he was an adult when the charges came forward, there was a Chapter 11972A hearing that took place, in which a judge in 2002 found not only was there probable cause that he had raped the younger cousin by force at least 5 times, and then also committed 5 separate rapes and abuse, but also an indecent assault and battery over 14 on each of those, the 2 victims as well. As an adult, the judge made that finding there was probable cause, and that it was such heinous, serious nature of the circumstances that in order to protect the public, this offender needed to be tried in the adult court, despite the fact.
That's all fine, but you're talking now as though this is all a punishment.
I'm not talking about his
Sounds
punishment.
that way.
I'm
I don't know,
suggesting-
why does that, the fact that the judge found that in 2002, looking back to 1988, have any relevance to whether in 2012, or whenever this is happening, there's a risk of reoffense?
Because I think in part addresses the passage of time. I think it also, when you look at the discussion that Judge McCallum gives that the hearing examiner adopts, talks about how this particular offender hasn't really grown out of what is being claimed to be this juvenile behavior, and that even as an adult,
How do we know that? What's the evidence of that?
I included it in my addendum, Your Honor, as well. It's in the discussion by the hearing examiner overlooking the court's order on the Section 72A hearing, in which she makes Judge McCallum makes a finding that the offender had made comments to the aunt, who was the parent or the mother of the two victims, basically saying he enjoyed it and he was taking advantage of these kids and that they were stupid, and that made it all the more enjoyable.
Stupid and weak.
Stupid and weak.
Judge Cosgrove, in his decision, actually lays this out
He relays
as
it out from
adult,
Judge McCallum.
adult conduct.
As an adult, this is what this offender is saying. So to make this suggestion that somehow because he was a juvenile he should be discounted when he is still engaging in that same type of minimizing, blaming the victim behavior as an adult, that's something the hearing examiner can certainly take
I
into
totally
account.
agree with that.
We're looking for conduct, not thoughts. We don't punish people for their thoughts. And if we're looking at this case, what he says doesn't amount to as much as what he does, which is nothing. How do you elevate that over the lack of culpable conduct over this decade?
I think part of it is it relates to whether or not he's accepted responsibility for his conduct and whether or not he has matured
Well,
out
who
of.
says that has to be a factor in the calculus, that he has to accept responsibility? Where is that written?
The hearing examiner has made that determination, so has the court. They've talked about denial and whether or not it's an important consideration to be made. And I think in this particular case, it's important.
Did he plead guilty?
Pardon me?
How did the conviction come about?
Pled guilty.
Right, he pled guilty.
He pled guilty to
So
all of
in a
it.
legal sense, you could say that he accepted responsibility and bore the consequences of criminal conduct.
He did.
Right. So
But
now we're talking about how many years later, and we're talking about somebody who hasn't been established to have some deviant mental illness and who has had no conduct for a couple of decades. That's reprehensible. That could predict future behavior. And that's a basis?
when you consider all the other factors that were applied in this case and the regulatory factors that were applied in this case, and you weigh them all out, that's where you come up with the one. And I would disagree.
Anybody not end up with one?
Well, you end up with a low risk. He's at a low risk.
Anybody get better than that? I mean, how do you do that? It doesn't seem possible.
Well, it is possible that there are offenders that are relieved of their duty to register, but in this particular case, the hearing examiner felt that there was still issues involved, that there was a cognizable low risk of reoffense, and that for public safety, this offender should be required to register.
Let me ask some questions about the guidelines that were used here. The amicus brief suggests that they were last updated in 2002. Is that correct?
That is correct.
So quite a lot has changed in the whole understanding of the juvenile mind since 2002.
Yes, and
Well,
yes and no.
and 2002 guidelines were perhaps based on information prior to that period of time. And we know from a couple of other areas that SORB has not exactly been on top of things in terms of updating its guidelines. We know that in terms of age-related considerations. We know that in connection with gender-related considerations. And so I'm really kind of interested in hearing what factors are in those 2002 guidelines that relate specifically to juveniles. To crimes occurring when people were juveniles that have not been repeated as adults.
Right, Your Honor. So if I may just go a little bit back and then come back to your direct question on the risk factors. I do want to point out that in this case, we had Dr. Schwartz's report, and she references Dr. Warling's eraser. And you've heard about the eraser from the earlier case. That's the study that's primarily cited by the board in its regulations, and it's still used. So although there's these other pieces coming out with regards to brain development for juveniles, the regulations are still good when it comes to juveniles because they are based primarily on the eraser that is still used for juveniles. So I did point out in my brief, and I can briefly address them here, Your Honor, as well, that there are several factors of the overall list that do not apply to juveniles at all. So I think that when you're taking the approach or comparing this case to the age, the elderly offender, the female offender, from the start it's different. The statute treats juveniles different, and the regulations and the risk factors treat juveniles different. This case is already starting in a different point than those other two cases. So for example, factors 1, which is mental abnormality, factor 6 is the ability to get out of prison early, and 9C6 are not applied to juveniles at all. And they weren't applied here. There are some factors that are not applied to juveniles who are under the age of 17 at the time of their hearing. Now, this particular offender was over 17 at the time of his hearing, given the facts. So the hearing examiner does take into consideration when he applies factor 9A, which normally doesn't apply, and he gives this offender credit for his offense-free time in the community. In addition, there are two factors in particular that are applied differently to adults than they are to juveniles, acknowledging that juveniles and adults behave differently, act differently, and offend differently. And that would be factor 3 and factor 7. Now, factor 3 is adult with a child victim. And it talks about how juveniles who offend against prepubescent children would be at a higher risk. That's dangerous. That wasn't this offender. This hearing examiner didn't apply that in this case. And then when you take it into sexual experimentation, the factor 3 recognizes that there could be sexual experimentation consensual between juveniles. That wasn't the case in this case either. This is a case where there was a rape with force. It's not consensual, despite the fact that that's what the plaintiff keeps alleging. There was force in this case. So the hearing examiner takes that into consideration in this case. And the other one I think is also related in the prior case is factor 7, the relationship between the offender and the victim. Now, what is known is that typically juveniles do exactly what this offender did. They target victims that are younger and known to them.
Did he plead guilty to rape of a child with force?
Yes.
He did 5 counts. And that is based on Judge McCallum's order. She found that there were 5 separate incidents of rape with force and 5 counts of rape and abuse of a child, separate and distinct, while the victim was still underage. And then the assaults continue until the victim becomes older. So with regards to factor 7, that was, again, also applied properly in this case. The hearing examiner recognized that this is typical juvenile behavior. The remaining factors get into sex offender treatment, and part of the problem in this case was the plaintiff had very little sex offender treatment. He certainly didn't have any as a juvenile because this hadn't been raised as an issue. But in a more general sense, I do want to point out that factor 14 specifically talks about the difference between juveniles and adults, and that comes directly from the statute. And these regulations are all consistent with the purpose of the statute, in which they talk about whether or not the offender was a juvenile when they committed their offense.
But let me ask you this. This is on Justice Lang's question. So they were written in 2002. Yes, they make a lot of distinctions between between conduct of juveniles and adults, which you have just gone through. But there has been a lot of development, I think, in terms of brain science between 2002 and now. Does the board have any plans to look at their regulations and maybe update them in this or other fields?
We are looking at them, Your Honor, and we're looking at a lot of research as well as from the other cases, from the age cases to the female offenders, as well as the juvenile offenders. Part of that is it's a large undertaking, and a lot of these studies aren't quite as clear as we would probably like them to be. A lot of them don't have the same conclusions. A lot of them talk about this is information that's still being developed. So at this point in time, yes, we're looking at them. We're taking into consideration the different studies that are coming out. But I will say that in particular with the juvenile offenders, one of the things that's still being looked at is the Whirling-Kerwin study and the eraser. So from that perspective, in terms of whether the regs are invalid, I would certainly argue they're not. They are consistent with the statute. And in particular in this case, They distinguish appropriately between juveniles and adults. And more importantly, this hearing examiner really took that into consideration. He didn't just give a blanket application of the factors. There's several times throughout his decision where he talks about, well, he was a juvenile when he committed it, he's an adult now, this passage of time. But at the end, when he outweighs all of it, he still finds that there's this repetitive and compulsive and predatory nature of this offender, which makes him very atypical for a juvenile.
Can I ask you this? Was there a claim at the hearing that the classification factors were invalid?
There was not, Your Honor, and there was not at the Superior Court either. They're sort of glossing around it, but this is the first time where it really becomes an asserted position, and the studies are used to make that position. And that is detailed at great length in our brief as well. If there are no further questions, Your Honors, I'd rest on my brief for the remaining issues.
Thank you.
Thank you.
Thank you.